Welcome to Senior Citizens Forum. I'm Janice Wood. The Senior Citizens Forum is presented by Benefits for You Too Insurance Services. And at Benefits for You Too Insurance Services, we specialize in Medicare and health insurance. Just like in previous shows, we're not going to talk about Medicare a lot, but I just want to emphasize how important it is that you know what your benefits are. There's so much phone calls going on, people asking you if you want to change your plan to a plan that you may get $125 back from Social Security. But are you losing benefits in doing that? So if you've done that and you're feeling like your benefits aren't as rich as they were, please give me a call, because at Benefits for You Too, we do a free consultation and we would love to talk with you. But on July 22nd, I had on Rob and Debbie Feldman, who have been real estate agents for, well, combined, I know it's way over 30 years, but Debbie has definitely been a real estate agent for over 30 years. And they were talking about how important it was to have a will and trust. And I mentioned my friend David Gerson, who's been on the show before in previous seasons, both on season 1 and season 2. But because I think the will and trust is one of the most important things we can do for ourselves, I look at it as a gift that we're leaving our heirs. David shaking his head, yes.
Absolutely.
I mean, there's so many things that go on with the will and trust, even though you don't want to spend the money up front, but you cannot believe what it will do for your heirs. May it be your children, may it be someone else, may it be an organization. So David, let's get started. Talk a little bit about your background. And I know you've been doing wills and trusts for a long time.
Yeah. I started as a litigation attorney many years ago. I was a divorce litigator in Chicago for about 15 years, starting in 1970. And then I moved out here. And in 84 and in 85, I started practicing law out here. And I've been doing trusts and estate planning for about 30 years. And I love it. I absolutely love it. I call it my atonement, because I leave families better than I found them. And so I do consultations, I do trust reviews at no charge. And selectively, I meet my clients either in their homes doing house calls or on Zoom, and things get done pretty well.
Yeah, well, I know personally, I've used Dave as my attorney for my will and trust. And before we started broadcasting the show, I was telling him I'm going to have to make some changes to my will and trust, because there's some changes going on in my life that's going to affect me, not only financially, but personally, like my health issue. Something happens to me, who's going to do that for me? Okay. So it's not only your real estate or whatever you have set up financially, it could be your businesses. All this is covered. And I know Dave is going to get more that's covered. Those personal possessions that I'm looking at that I haven't written down, who goes to what, okay? But it's all those things. And why is that will and trust so important? I'm going to say, because you don't want to go to probate.
Very true. Very true. People don't realize. Everybody hears war stories. Everybody hears someone say, oh, you don't want to go through probate. But they really don't understand it. And the average probate in Southern California is 2 years. That's a terribly long time to involve your family in the chaos and the drama and not be able to move past an event which tears them apart every day. Additionally, probate on average, the estimate is 8% of gross value goes to probate related costs. 8% of gross value is a tremendous amount of money. Just for an example, if you have, let's say you have a house worth $500,000. In Southern California, that's rare, but let's say you have a $500,000 house, but you have a mortgage on it for $300,000. So what's the house worth? I mean, the equity in the house, the net value is $200,000. The gross value doesn't consider what you owe on it. If the house is, $500,000 on the market, they don't care what you owe on it. The gross value is $500,000. And so it may cost you 8% of $500,000. And that, pardon me, is around $40,000 to probate that house. I'm sure we can all think of better places to put $40,000 than probate.
I mean, I can think of a lot better things to do with that $40,000. Now, I know, and I'm talking a long time ago, I had to go through probate because my father didn't have a will and trust. It was a pain. Not only are you paying the lawyer's fees, then you're also paying for the fees for the state, which you said was 8%.
Everything combined, it's a huge amount of money. There's no way to justify that if you have a better solution.
Right.
And a trust is a better solution. Trust is fast. Trust doesn't cost a lot of extra money. Trust is private. Everybody can't walk into a probate clerk's office and get a copy of all your documents, your inventories, who's going to inherit and where they live. It's private. It's your private business. There's a whole lot of reasons that prove why trusts are so popular.
Okay. So real quick for us, we're talking about a will and we're talking about a trust. Okay.
Yeah.
So what is the difference between a will and a trust?
A will is a ticket to Disneyland. It's a ticket to the long ride. It's a ticket to probate.
Okay.
A trust avoids probate. Now, in a good, comprehensive estate plan, you're going to have both. You're going to have a trust, which is going to handle everything.
Mm-hmm.
But you're going to have a very peculiar will called a pour-over will. And this is a will designed specifically to work with a living trust, and it is a safety net. When you get rid of all the legal mumbo jumbo, a pour-over will basically says, when I die, if I forgot to put something in my trust, I leave it to my trust.
Okay.
So if you have a good estate planning attorney who puts together a comprehensive estate plan, it's going to contain both those documents, and he or she will sit with you and tell you specifically how to put every one of your assets into your trust.
And you can do that, right?
I do that. That's my job.
And
there are a lot of other documents that you need. And before we leave the issue of a will, there's another reason to have a will, and it's an extremely important reason for younger client families, and that is families that have minor children. They want to name a guardian for their children in case they're gone. Under California law, you can nominate a guardian only in a testamentary document. That's the legal mumbo jumbo.
Okay.
What that means is it's a document that's implemented on your death. And so a trust is not a testamentary document because that's implemented as soon as it's signed and notarized. A will, although it's signed and witnessed during your lifetime, isn't implemented until you die. So in the will, you nominate your guardians. Very important thing to know. I've seen documents prepared where in a trust they try to nominate a guardian, and it's not going to work. That's not what the law is in California.
So that's important to make sure you get that in writing. Yeah.
And in the proper writing, it's got to be in the will.
Okay. So would it be the proper in the legal way is what I would say.
Yes,
Everything has to meet a legal standard.
exactly.
All right.
And so, you know, those are two really important documents.
Well, what other documents are we finding? We've talked
You-
about real estate because we led in with real estate, but there's more than that in a will and a trust, okay?
Well, of course, if you, people frequently ask me, so who needs a trust? And my canned response, the response that I have memorized for 30 years, it hasn't changed. If you own real estate and you live in California, you need a trust. It's that simple.
Okay.
Because real estate in California is going to go through probate unless you have a trust. What you do if you have a trust is you put your real estate in the name of your trust. Why is that? Because when you die, your trust doesn't die. It's kind of like a corporation. It continues after your death. And you have appointed successor trustees who will manage your trust after your death so that your goals and your objectives are accomplished. And one of those can be distribution of real estate. So if you don't have a trust, how do you distribute real estate? Well, real estate is distributed, conveyed, transferred by a deed. That's a paper document, and it requires a signature from someone authorized to sign it. If you're the owner and you're dead, it's really, really hard to get you to sign it.
Yeah.
That's why probate judges are in business. What they do is they appoint an executor. Frequently, it's the person who is named in the will and nominated in the will to be the executor. And they tell that executor, okay, I as judge authorize you to sign a deed conveying this real estate to whomever is going to get it. If you have a trust, you don't need to ask permission of a judge because the trust owns the real estate. The successor trustee has the legal authority to sign a deed on behalf of the trust. And that's the simple elegance of a trust.
But
It works.
I mean, if you own, let's say, apartment buildings or you own other land,
Doesn't matter.
it doesn't matter. It all
Doesn't
could
matter.
go into the trust.
If you own real estate,
Okay.
let's say, start with this foundational soundbite of real estate. Real estate gets probated in the county where it sits. So if you have real estate in Orange County, California, and you have real estate in Sacramento County, California, and you have real estate in Clark County, Nevada, you're going to have 3 probates. And then you have that real estate down in Florida, 4 probates. If you put all of those probates in your trust, there is no probate anywhere.
Okay.
I have one guy who had 35 investment properties around the country. Can you imagine the dance that would have been for his family?
Oh, I could see it dividing the family.
All of those properties went into his trust, and there were no probates anywhere. Everything was handled conveniently, easily, without drama, without chaos, from the desk of the successor trustee.
Now, let's just say that this person had the 35 pieces of property and didn't have a will and trust, okay?
It's going to be 35 probates.
Okay, what about the emotional part of fighting with other family members or a
Well,
partner?
that's the thing.
Yeah.
It doesn't take 35. It can take one house, and you'll have disruptions in the family. People change when money hits the table. Sad.
Oh, yes.
That's why most wills and trusts have a no contest clause.
Mhm.
Every trust that I've ever prepared has a no contest clause. And what that does is it protects the integrity of the trust. And it does it by saying, basically, any beneficiary or person who thinks they should have been a beneficiary who disputes the validity of the documents or disputes the distribution plan without an exceptional reason
Mhm.
forfeits 100%. So what's an exceptional reason? There are very few of them. And they almost always rest on the question of free, knowing, and voluntary act. So if somebody could prove that the person signing the trust, we call them a trustor, if they could prove that the trustor was legally incompetent at the time they signed the trust document, that would be a good reason to dispute the trust. If they could prove that the trustor was under duress, was threatened, forced into signing the document,
Mhm.
or was defrauded into signing the document, so that they could prove that it wasn't a free, knowing, and voluntary act, that would be a good reason. It's not fair. I cared for him for the last 7 years of his life is not a good reason.
Well, I can.
I
really-
walked his dog every day, 3 times a day for 4 years. Not a good reason.
I can give a personal example. My brother lived in another state when my mother got very ill, and I knew we both paid for her to have a will and trust. Okay, so when she got ill, of course I'm the one that was taking care of her. So I just said, well, if you're not going to come help out or do certain things, I think we need to change the will and trust, because I'm doing all the work and you're just sitting there doing your thing. And he goes, no way. And I just said, then you're going to start doing some stuff.
Yeah, because you can't change a will or a trust after someone has
That's right.
passed.
And we both
And-
were very
And
aware.
you couldn't change it when they were alive either. They have to change it. They're the only ones who can.
Well, I want to go back to what else is in the will and trust, but I want to go to what is a revocable will and trust and a non-revocable will and trust.
Okay, we call that an irrevocable trust. And I have to get you to stop saying will and trust like it's the same thing. They're independent legal documents. They have, they are not married at the hip. The A revocable trust is used well over 90, maybe even 95% of the time for people who are doing estate planning. It allows them to change the terms, to change trustees, to change anything they want, anytime they want, as long as they make the changes properly. And I can talk about that a little later.
Yeah.
And any taxable events that occur on trust-owned assets on a revocable living trust, which is called a revocable grantor trust under the Internal Revenue Code, are reported on the trustor's normal 1040, just like always. They just one tax return for the family and it's done.
Mm-hmm.
An irrevocable trust is a different animal. And an irrevocable trust has restrictions on it. Most people who want irrevocable trusts want them because they want to protect assets from creditors instead of avoiding probate. And an irrevocable trust can do that if all the planets are aligned properly and the wind is at your back and you're going downhill. Assuming everything works that way, an irrevocable trust means that the person creating that trust and signing that trust, the trustor, can't be the trustee, can't manage it on a day-to-day basis. They have to have someone else. They have to have someone else manage it. And frequently, there are restrictions on who can manage the trust. Having a trustee that is a person subservient to the trustor is frowned upon, because they'll say, you know, that having your spouse or having your child as your trustee is your alter ego. You know, and there's an argument to be said for that. You can't make changes to the trust because it's irrevocable. It's carved in stone. And because it's irrevocable, you have to file a 1041, a fiduciary tax return for the irrevocable trust every year. So every year you're going to have a CPA bill of at least $1,500. Mm-hmm. And you're going to have to pay taxes on any taxable events that occur on trust property, in addition to filing your own personal 1040.
Whoa.
It's a real pain in the neck.
Okay.
And I don't promote them.
You don't promote that. Well, my question is, because I have a friend whose husband passed away and she has an irrevocable trust. And situations change when you have a joint irrevocable trust. And it's just like, I keep thinking, why did they do that?
I have no idea.
I mean, I know
I'm sure that they had a reason that made sense to them. I don't know if they had an adequate and sufficient consultation with an estate planning attorney to point out the pitfalls. I don't know what their goals and objectives were.
Right, but
it's possible that they had a valid reason for doing what they did. It's equally possible that they didn't truly understand what they were doing when they did it. And now there's hell to pay.
Yeah, that's very scary.
Yeah.
So I want to move on to what else you find in the trust, okay?
Well, if you want to talk about other documents.
Other documents, I'm because I do health insurance and Medicare insurance, I really want to go into that area because that's so important.
It's critical. It's critical. Okay, first we have to get the concept of independent legal significance. What that means is an estate plan will have a whole bunch of documents, and people will collectively refer to it as a trust. It's not. The trust is one of the documents, and it's the foundation document. But the will is independently legally significant.
Okay.
The power of attorney for healthcare in California is called the Advanced Healthcare Directive. And that is also a independently legally significant document. The purpose of the healthcare directive is to appoint somebody to make healthcare decisions for you when you are unable to make those decisions yourself. Okay? It's a relatively straightforward document that some people feel the need to encumber with many, many, many add-ons. The purpose is to provide clarity in a very unambiguous way so someone can make medical decisions that you want when you can't make them. If you give too much leeway, what you're providing is a roadmap to guilt. Let me tell you what I mean. There was a fellow I went to law school with many weeks ago, and his dad got very sick all of a sudden. And my friend had to make the decision to take him off life support, to pull the plug. Now, he knew intellectually that he was making a decision his father would have wanted him to make had they ever talked about it. But because they hadn't talked about it, it was his decision. And for 40 years, he carried that guilt on his shoulders that he did it. He pulled the plug on his father. When we were going through this many years ago, and my daughter, who was around 15 years old, didn't want to talk about it. She says, I don't want to talk about that. I said, well, we have to talk about it. This is important. She said, I really don't want to talk about it. And after a few back and forths, I said, look, I've got good news and I've got bad news. And she said, what's the bad news? I said, the bad news is I'm dying. And she looked at me and she said, what's the good news? I said, I'm doing a really bad job of it. But one of these days, I will get it right. And along the way, one of you, talking to my family, may be in a position where they have to decide whether or not it's appropriate to pull the plug. It's really critical that you understand this. It's okay to feel bad. It is not okay to feel guilty about it because you had nothing to say about it. I put it in writing. This is what I want you to do under these circumstances. I made the decision and I put it on you to execute that decision because I couldn't. If I could, I would. But if I'm in a position where I can't, you owe me the responsibility to do what I can't do. It's not yours to carry, and you have no guilt. That's critical, really critical, to remove guilt. So, what about the Advanced Healthcare Directive that everybody needs to know? Under California law, it can go into effect at 2 times. The first time is only when your primary physician determines that you need it. This opens the door to having a primary physician obstruct your agent, because he can say, oh, he doesn't need you right now. I don't think she needs you right now. And so they can obstruct you. So they don't have to give you records. They don't have to do a lot of things. The other time it could go into effect is immediately. And sometimes I'll have clients who will say, but what if they make a decision I don't like? The whole idea of a power of attorney is based on the old common law of England of principal and agent. An agent cannot make any decisions that the principal will contravene. Period.
And,
Can't do it.
and I can talk about an example that I just went through a couple of months ago. I had a share power, medical power of attorney for a friend who had no family. And she ended up in the hospital with COVID pneumonia. And I get a phone call saying, well, do you want us to continue her on life support? What do you want us to do? I asked specific questions. And then I had to go back and consult with the other two people. It's very emotional. It's very hard. But then I called up home to my office and I had somebody pull her medical power of attorney, which I felt the hospital should have had, okay?
Yes, they should.
And I said, what does it say in there exactly what she wants? She said, no dramatic, whatever the proper words are, to save me. I went back and I asked, well, what is the diagnosis? And I was told extremely poor. And I'm going, then I just want her to pass peaceably according to what I just read.
Well, that's it.
And it's emotional to make that decision for someone else.
Yeah. The Advanced Healthcare Directive has two choices. You can choose not to prolong life. You can choose to prolong life.
Right.
30 years, I've had 4 or 5 people choose to prolong life.
Yeah.
Everyone else doesn't do that because it says in the document, if I'm suffering from a fatal, irreversible, incurable disease that will kill me in a relatively short period of time without medical intervention, I'm not going to have any quality of life. Let me go.
But what I'm trying to express is the emotional part of it, okay? And trying to make that decision is very emotional.
Yes,
and
but
I wouldn't have had something there written down, then I would have had to take a different direction.
Yeah, because now you know the decision was made.
Right.
And that's really critical because it removes guilt. It puts responsibility where it belongs.
Right.
Okay. Now, you said something really interesting. And that was hospitals should have that. They did. Because if you don't bring them your documents, they make you sign theirs. I'm not a fan of their documents.
Interesting. Okay.
Their documents, their Advanced Healthcare Directive becomes effective only when your primary physician determines that you need it. Unless you check a little box that's usually hidden in the middle of the paragraph where nobody ever looks.
Yeah.
To make it effective immediately. They want control. What I do is I tell my clients when I'm delivering documents, and my clients have 3 documents related to healthcare. One is the directive. The other is a HIPAA release, because you have to have that if you want to find out what's going on. In any event, what I tell my clients, I want you to make photocopies of these documents. I want you to take a set of documents and make, get an envelope, get 3 envelopes and 3 sets. On the envelope, write your name and write medical. The next time you go to your doctor, take it into your doctor, hand it to the receptionist. They will either scan the documents into your record or they will take the physical photocopies and put them in your physical file. If you go to a hospital, grab one of those envelopes and take it in with you. By having them pre-done and easily accessible, it makes it extremely easy to take them in when you need them.
Yeah. Well, one of
I
the,
want clients say, I'm going to make a set, keep it in my glove compartment.
well, under this situation, one of the things that we had to do was we scanned the documents and sent them over to the hospital saying, we have, this is our right.
Yeah.
Yeah.
And so that's what you do. And you make sure that your doctors, your clinics, your hospitals all have a copy of them. And you keep a few sets of them in envelopes, easily handed, boom, grab it and go.
Okay.
And that covers it.
Okay.
Now, you also need a financial power of attorney. And people always say, what do I need that for? Everything's in the trust. Doesn't the trust govern everything? Yes, the trust governs everything in the trust. And there may not be a lot of exposure to having financial assets, checks laying around the house and stuff like that. But there's one paragraph in the financial power of attorney, if it's properly crafted, that's really important. And that protects you from the state of California ever becoming your conservator. You never want that.
No.
You know what a conservator is.
Yeah.
It's a guardian for grown-ups.
Oh, I mean, we've heard a lot about it with Britney Spears.
Yes,
That's been a real.
they put their people in your pocket and they run your life. Horrible, horrible, horrible situation.
You know, it is.
So there's a paragraph in every power of attorney, asset management power of attorney that I prepare, and should be in every one that anyone prepares, that basically says if there's ever any proceeding initiated to have a conservator appointed for me, meaning the state,
Okay.
no one else is going to do it, I nominate my people.
Okay.
And when the state sees that, they walk away. They are not going to dedicate time and effort and resources unless they know they're going to win. And in that situation, they know they're not going to win. So they just walk away.
Okay.
They won't attempt to take control of your life and your assets.
Okay.
Very important.
Just real quick, because we're going to start running out of time here, okay? Because we've been talking for quite a while, all right? So what if I don't own any property?
If you have assets that in the aggregate, financial assets that in the aggregate are worth more than, let's say, $165,000,
Mm-hmm.
you need a trust.
You need a trust. So I may not own property any longer, but I could have like the
You may have brokerage accounts,
Or-
you may have CDs, you may have investment accounts.
but I
You
could.
want to make sure that this is handled.
Yeah, I could have jewelry
Yes,
or a piece of fine art.
yes.
I'm just trying to think, or
Yeah.
that car in
And-
the garage.
It becomes really, really important. And there are times when you don't have all that much. I had a couple several years ago that wanted a trust. They didn't own a house. They lived in a rental. They had a very used car. They didn't have anything of any real value. I mean, their assets, if they totaled $15,000, that was a high end. The wife had a 401k, and she had $140,000 in it at that time. They had two children. One was a son, and he was a financial advisor. He was happily married, had a lovely wife. They were not able to have children. The other was a daughter. She was married. Her husband was in prison. She should have been in prison, but she escaped because they had two little girls. And the clients wanted to dedicate their 401k earnings to their grandchildren. They knew that if they let their daughter anywhere near the money, the grandchildren would never see it. And so they wanted a trust so that they could have their 401k pay into the trust to be run and managed by their financial planner's son, so that the money would be preserved and managed properly and grown. So when these little girls grew up to need a college education, there would be a fund to pay for it. And the girl's mother would never be able to interfere with that, never be able to misuse the funds.
Mm-hmm.
And so on the face of it, this couple had no reason to have a trust, but on close examination of their objectives and their challenges, a trust became a perfect vehicle.
Right. It's so important. There's so many different types of scenarios.
Yeah.
And just quickly before we wrap up, I know I have some friends that are seniors. Their adult children are still dependent upon them because of health issues, okay, or mental type issues. So I know there's something called a special needs trust.
Yes, I have always included special needs trust provisions in every trust I prepare. It's rare that I encounter a trust that I didn't prepare that contains these kinds of provisions. And that's because most lawyers just use software packages that they really don't want to go into and change. And they buy it, they use it, they don't know what. Anyway, my trusts contain special needs provisions that provide any beneficiary who has special needs and has to address or apply for benefits from a government program like SSI or like Medi-Cal that would likely disqualify them because they have an interest in the trust. The program is going to tell these people, you have assets, spend them down. When you're broke, come back, then we'll talk to you. Maybe we can help you. In my trust, anybody in that circumstance is immediately removed as a general beneficiary so that they qualify for that government program.
It is so important. You used a word called Medi-Cal, and I know that we have people that watch this that are from other states. Medi-Cal in the state of California is actually Medicaid all over.
Yeah, same thing. Their share does not disappear. It goes into the special needs trust, which is defined by its terms to supplement government support. So the agency can't say spend it down first. If you otherwise qualify for the program and you've got this huge trust asset, it's supplemental to government support. They have to take you. They have to enroll you in the program. They have to give you the benefits. And you get your trust too.
It's just,
I always tell my clients, be sure everybody knows if they're ever in that situation, don't live large. If all you need between what you're getting from the government program and living a comfortable life is $2,000 a month, take an allowance. You don't know how long you're going to need it.
right. You don't know.
Be smart.
It's so important.
Yeah, it is.
For your adult children to be taken care of.
Yeah.
And the situations are out there. Which
Happens
is
more than we would like to see.
Right. And I can think of several right off the top of my head, people that I'm associated with. Yes. through what the
We
different.
try to cover that.
Yeah, which is, it's really sad. So this has been a lot of fun. I would recommend to people that go back to our previous seasons. You can go into Dave's site, you can go into my site, and you can bring it up either on podcasts or Instagram, because we post it in every place, Facebook, and look for our previous shows, because in each of the shows that he and I have done together, we have covered something slightly different. And I would recommend going back and looking at those shows. I know I'm going to ask Dave back on next year again, and I know we're going to cover something slightly different again. But a will and trust, as I said at the very beginning, is the best gift you can leave your family.
Yeah.
Because you're not going to have them going through probate, which is what Dave said, 8%. 2 years of their lives are tied up and going through this probate. And also, you're not having your family go through emotional things of arguing with each other over money. Money can become an ugly situation. And you don't want to split your family. You want them to stay together.
Yeah. You
I don't
want to
know.
manage the warfare.
Yeah, right. I don't know how else to put that. Okay. But it is, you would have to talk about Dave personally about what his fees are. But one of the things that he and I both do, we provide free consultations. We meet with you in your home or a place that you designate, or we like doing Zoom, okay? So, and we don't charge for those consultations.
That's true. And I do free trust reviews as well.
Okay. And I'm going to be having, because I'm having some changes in my life, and I'm going to be looking at my business, which is not part of my will and trust right now, which I'm going to be bringing in. And there's some changes going on personally in my life. So he's going to be looking at it. Also, if your trust is over 5 years old, it's a good idea to have the review, and you can correct me if I'm right or wrong. You can tell me, because the laws can change.
It's not just the laws change. Unfortunately, I've encountered, and I've reviewed thousands and thousands of trusts. I've encountered too frequently people who have tried to make changes on the trust itself. They didn't know any better. Scratch something out, write something in. Arguably, they've invalidated the document.
Mm-hmm.
Or I've encountered people who look at me in surprise when I tell them what the trust does and say, they'll, I didn't want that.
Right.
How did that get in there?
Mm-hmm.
You know, it makes good sense
Okay.
to review it. If you haven't had a life event, review it every 5 years.
Yeah. So it's real important, because what you had 30 years ago, which you were raising your children, is not going to meet your needs of today.
No, it won't.
Right. And things change. Your health changes, your assets change, and your relationship with your families can change.
Yes.
So
All good reasons to
Um,
review.
to have that reviewed.
Yeah.
Especially, and I know this is really hard if you just became a widow or a widower, that makes it even more emotional, but it should be reviewed.
Yes,
So Dave, this is always a pleasure.
it's always
We
mine.
are going to have on here how to get in touch with you. I've heard Dave going all over California, up to Northern California, because we're both located in Southern California.
Yeah, I've
People.
delivered trusts all over the state of California.
So this is like, and I see Dave on a weekly basis.
Yeah.
And he's always talking about how important the will and trust is. And I know nowhere else I can go with that. So thank you, David, for being on my show again on the
It's
Senior
my
Citizen
pleasure.
Forum. And it's always been fun and informative. Have a great day, okay?
And you too. And everybody out there, stay safe. Be
Yeah.
well.
And